It started with a photograph, a single image of a sitting Wisconsin judge in handcuffs dragged from her courtroom, posted by the FBI Director himself. For Senator Chris Van Hollen, that tweet wasn't just a misstep, it was a warning shot at the heart of American justice. In a tense Senate hearing, Van Hollen accused FBI Director Kash Patel of violating the Department of Justice's own media policy and trampling on the principle of due process. What unfolded next was a searing indictment of leadership, law enforcement optics, and constitutional responsibility.
On the Constitution, because, as you know, in response to a question that the President was asked about whether he had to comply with the Constitution, he said, and I'm quoting, "I don't know." So it is important that we reaffirm everybody's obligation to comply with the Constitution, and I appreciate that was your answer broadly to the question asked by Senator Merkley. But you don't dispute the fact, and I'm quoting here from the Supreme Court opinion in Reno v. Flores, where Justice Scalia wrote, and I quote, "It is well established that the Fifth Amendment entitles aliens to due process of law in deportation proceedings," end of quote. You don't dispute
I don't dispute that.
Okay. Just wanted to make sure, for the record, we understand that, because as you well know, the federal courts have found that there have been gross violations to date of many individuals' due process rights. Let me ask you a question about Judge Dugan, and I'm not going to get into about Judge Dugan, who was arrested, taken out in handcuffs from her courtroom. You agree that as director of the FBI, you should lead by example, right?
Try to.
Okay. Well, there's a confidentiality and media contacts policy within the Department of Justice guidelines that says specifically that DOJ personnel should not voluntarily disclose a photograph of a defendant unless it serves a law enforcement function or unless the photograph is already part of the public record in the case. Clearly, Judge Dugan's photograph was not already part of the public record in the case. So it appears that what you did was a violation of that policy, unless you can express a clear law enforcement purpose for having done that.
The simple law enforcement purpose is to show America that we investigate any individual who commits a crime, especially those in positions of public trust.
But do you agree with the presumption of innocence in the U.S. system?
Absolutely. As a public defender, that's what I fought for years.
Well,
but that's different than
no,
this.
But Mr. Director, this is one of the reasons why that guideline is there, so people, especially the director of the FBI, doesn't announce to the country that somebody's already been found criminally liable when they haven't. She hasn't, has she?
But that's not what we said, that she was criminally liable. We said she was arrested and showed it.
Yeah, we know she was arrested, but the issue is the photograph. I'm asking you, going forward, I hope as the leader of the FBI, you will comply with the guidelines of the FBI that everybody else is expected to follow.
I believe I have, and I will going forward.
Well, this seems like a direct violation of this guideline.
I guess we're in disagreement, Senator.
Well, unless you can tell me why that really serves a law enforcement function. So you're going to send out pictures of everybody that's arrested?
Lots of people that are arrested have pictures sent out.
I'm asking you as director of the FBI, is that going to be your policy, just to start sending?
No, we do it on a case-by-case basis.
Yeah. Well, the guidelines make clear that I think any normal interpretation of this suggests it's a violation. Look, we're a budget committee, an appropriations committee. We want to find a way to make sure that we properly resource the men and women who work at the FBI. I think that is a common goal, I hope. And I do, just, Mr. Chairman, again, in closing, I understand you want to proceed, just so that we keep things going, but it is kind of hard to proceed without any budget. So.
I don't take you as critiquing our having a hearing.
No,
you're pleased to have a hearing, and I wish we had more to deal with than we do.
I do.
And
The Senate hearing that unfolded this week was supposed to focus on the FBI's budget and resources. Instead, it became a dramatic clash over due process, constitutional values, and the power of public perception. At the center of it all was a tweet, an image of Judge Dugan, a sitting Wisconsin judge, being perp-walked in handcuffs, posted by FBI Director Kash Patel. For Senator Chris Van Hollen, that act represented far more than a lapse in judgment. It symbolized the dangerous erosion of foundational principles that are supposed to guide law enforcement in America. The confrontation began when Van Hollen pressed Patel on the core issue due process. He reminded the FBI director that the Supreme Court has long affirmed, including in Justice Scalia's opinion in Reno v. Flores, that even non-citizens are entitled to due process of law in deportation and criminal proceedings. "You don't dispute that," Van Hollen stated, to which Patel agreed. Yet the senator noted that federal courts have already documented gross violations of due process rights in other cases, making adherence to these principles not just theoretical but urgent. From there, the hearing turned to the arrest of Judge Dugan. Van Hollen recounted how she had been taken from her courtroom in handcuffs, and how Patel's decision to post the photograph on social media flew in the face of the Department of Justice's internal media contact policies. Those guidelines are explicit. DOJ personnel are not to voluntarily release photographs of arrested individuals unless the image serves a clear law enforcement function or is already part of the public record. Judge Dugan's photo was not. "So it appears that what you did was a violation of that policy," Van Hollen said bluntly. Patel's defense was equally blunt. The purpose was to show America that the FBI investigates anyone who breaks the law, even public officials. But to Van Hollen, that answer exposed the core problem. A public relations message is not a law enforcement function. The presumption of innocence, he reminded Patel, is a bedrock of the American legal system. By releasing the image, the FBI risked broadcasting to the nation that Judge Dugan was already guilty before she had her day in court. Optics, Van Hollen warned, can undermine justice as powerfully as any action in a courtroom. The senator pressed Patel repeatedly, asking if this was now to be the FBI's policy, tweeting out photos of public officials under arrest regardless of the circumstances. Patel admitted the agency makes those decisions on a case-by-case basis, which to Van Hollen suggested an even more dangerous possibility: selective enforcement based on convenience or political optics. Once law enforcement leadership begins deciding who gets public humiliation and who gets quiet discretion, he argued, trust in the system erodes. The exchange underscored the difference between law and spectacle. The Department of Justice created its confidentiality guidelines for a reason: to prevent prejudgment, to protect the rights of the accused, and to keep law enforcement from slipping into the realm of public shaming for political or media gain. By bypassing that safeguard, Patel turned the FBI's immense power into a tool of messaging rather than justice. As Van Hollen implied, the tweet wasn't just a photo, it was a message, one that said guilt could be implied with an image alone. The hearing also exposed a troubling contradiction in Patel's stance. He insisted that he respects the presumption of innocence, citing his years as a public defender. Yet tweeting out a handcuffed judge sends a signal to the public that the FBI is already framing the narrative: no trial necessary. This isn't theoretical, it's the reason DOJ rules exist. Once a person has been presented to the public as guilty through optics, the damage to reputation, career, and public confidence can be irreversible, even if a court later finds them innocent. Van Hollen closed the confrontation by tying the issue to the larger purpose of the hearing: the FBI's budget and congressional oversight. "We want to properly resource the men and women who work at the FBI," he said, but he questioned how Congress could fulfill that duty when the Bureau's top official openly sidestepped internal rules. Oversight requires trust. Without adherence to the very standards the FBI expects its rank and file to follow, that trust crumbles. The moment captured in that committee room wasn't just about Judge Dugan or one controversial tweet. It was about the rule of law, the delicate balance of power, and the expectation that those who enforce the law must follow it themselves. By calling out the director, Van Hollen made clear that the issue reaches beyond partisanship or personal embarrassment. It is about whether Americans can believe that their justice system operates on fairness rather than favoritism, law rather than publicity, substance rather than spectacle. The hearing ended without resolution, leaving the core question hanging in the air: will the FBI hold itself to its own standards, or will it continue to gamble with the perception of guilt in the court of public opinion? For now, Patel's case-by-case defense offers little reassurance. The damage of a single photo can last longer than any headline. And if the guardians of justice cannot uphold their own rules, the public's faith in due process may become the next casualty.